Salutations to all our future judges. In this video, we are going to see the Code of Civil Procedure 1908, Part 8, Sections 27 to 34. If you have not seen the past parts, that is from Part 1 to Part 7, I am providing the playlist in the description box. You can click that and watch all the 7 parts. In addition to this, if you have not seen only Part 7, I am providing the link in the iCard. Summons and Discovery. Section 27. Summons to defendants. Generally, when a suit is instituted, summon is served on the defendant, asking him to appear and answer the claim. Simply, we can understand that when a case is instituted, the court will send a summon to the defendant asking him to give his explanation about the claim which has been made. And it should be served within 30 days from the date of institution of the suit, and it may be served in a manner prescribed. For example, the court may say you have to serve this summons in this manner, then you have to serve it in that particular manner. That is section 27. Let us move to section 28. Service of summons where defendant resides in another state. There may be cases where the defendant is residing in another state. Then how the summons can be served? In this 28 subsection 1, the rules which needs to be followed when a summon is sent to some other state is the rules which is followed in that particular state. For example, if the summons is sent from, say, Tamil Nadu to some other state in north, say Madhya Pradesh, in that case, the rules of Madhya Pradesh will apply with respect to that summons. This is 28 subsection 1. Let us move to 28 subsection 2. Imagine the court which is in Tamil Nadu is sending its summons to a court in Madhya Pradesh. Then that Madhya Pradesh court shall proceed as if Madhya Pradesh court itself has issued the summons. That is the first point. Second aspect is, once Madhya Pradesh court issues the summon and the summon is received or rejected or whatever it may be, it should return the summons to the court of issue, that is to the court of Tamil Nadu, with record of its proceedings. This is the second point. Let us move to section 28 subsection 3. Imagine there is a state in which the language is not Hindi, not English. For example, Tamil Nadu. Here generally in the lower courts, Tamil language is used. In that case, if they are sending a summons to Madhya Pradesh court, they have to translate that into Hindi or English. This is 28 subsection 3 subclause B. Imagine if it is a Uttar Pradesh court. Uttar Pradesh court is sending a summon to Madhya Pradesh court. Uttar Pradesh court also the language is Hindi. Madhya Pradesh court also the language is Hindi. In that case, they can send it in Hindi, no problem. Along with this translation, record should also be sent. Record plus its translation should be given to the other court. Let us move to section 29. Service of foreign summonses. Imagine there is a scenario where there is a civil or revenue court for which the CPC will not apply. Civil procedure code will not apply, to which this civil procedure code does not extend. 1. The second scenario is there is a civil or revenue court established by the central government outside India. It is not inside India. And the third option is where the central government says that this particular section or the provisions of the section will apply to a particular civil or revenue court. In all these cases, the summons shall be sent to the court within that territory to which this code extends. For example, imagine there is a revenue court A inside a state for which this civil procedure code will not apply. There is another court very near to that court or having jurisdiction or within the territory of that court, which is court B. And for that court B, civil procedure code will apply. In that case, what will happen is this A court will send its summons to the B court, requesting that B court to serve, and in that case we should presume that it is the B court which has issued the summons. B court should act as if it is directly giving the summons. Let us move to section 30. Power to order discovery and the like. In some cases, the court may feel that there is a necessity to find out certain things. In that cases, what the court will do is the court will try to discover things, and this can be done at any time, even at the time of argument, even after the argument, even before the disposal of the case, it can be done. And the court, if it feels it can do it on its own motion, we simply call it a suo motu. Or if a party applies to the court saying that you please discover these facts. 30 subclause A. The court can make any order which it feels necessary or which it feels reasonable for identifying certain things. It may be for interrogatory, it could be for admission of a document or fact, or they may try to discover, inspect, produce, impound, or written documents or other material objects which can be used as evidence. Let us move to B. It can issue summons to person whose attendance is required. For example, if there is a person B, he has not been included in the case, but he is very well connected to the case. He is a good witness to this particular fact. Then in that case, the court will say that person to come to this court and give evidence, or the court can say you produce this document or produce this object. And the third, which is C, is it can say like you prove this fact by way of an affidavit. You file an affidavit and prove this fact. These three things can be done under section 30. Let us move to section 31. Summons to witness. If there is a witness, how the summons need to be served on the witness and for what purposes it can be given. Simple thing is the court can ask the witness to bring a document and give it to the court. Or it can say like you produce some material objects to this court and this summons shall be given in accordance with section 27, 28 and 29. Let us move to section 32. Penalty for default. In general, if court is asking for the attendance of a person, the person has to attend the court. So the court can compel the attendance of any person based on a summons issued under section 30. And if that person is not going to obey the order of the court, then what the court can do is explained under this particular section. The first option is the court can issue a warrant for his arrest. The court can issue a warrant and ensure that he is arrested. Then the court can attach and sell his property. The third option is it can impose a fine on that person and that fine should not exceed 5,000 rupees. And the fourth option is the court can ask him to furnish a security. Simply the reason for asking him to furnish a security is to ensure his appearance. And in case if he defaults, he can be committed to civil prison. Let us move to section 33, which is judgment and decree. In general, when a case is conducted in a court, after completion of all the procedures or proceedings in the case or in the suit, the court will finally pronounce its judgment. The first part is pronouncing the judgment, and following the judgment will be a decree. So the first thing is judgment, following that will be decree. Let us move to section 34. There are three aspects in this particular section, that is section 34, interest. The first point is that from the date of loan, that is when you took the loan, from that date till the suit date, that is one part. Second part is duration of the suit. So this is the second part. And the third part, what we see is from the date of decree to payment of money, to payment. So there are three parts which you need to understand in this particular section. So what happens is, if it is the first part, that is, imagine I am paying loan on this day and you are not repaid the loan. Then I am filing a suit after say 3 years or say 2 years. So till this 2 year, you have to pay the interest as agreed. Or if that is not agreed, then the court will determine a reasonable interest. This is first part. Let us move to the second one. Duration of the suit. That is, I filed the suit today. The suit is getting over after 3 years. So within this 3 years period, how much interest you have to pay? That will also be determined by the court. With respect to this particular third point, it will be not exceeding 6%. So the interest should not exceed 6% from the date of decree to the payment of the amount. However, if it is a commercial transaction, they are saying provided what it should be done. In case of commercial transaction, this can exceed this 6%. There is no problem. It can exceed 6%, but it shall not be more than the contractual rate. If there is a rate which has been agreed between the parties, for example, they agree on 12%, then it should not exceed this 12%. It can be 11%, 10%, it can be anything, but it cannot exceed 12%. And if there is no such contractual rate, then for commercial transactions, the nationalized banks render money on interest. Then that interest rate will be counted. Now let us move to explanation 1. Nationalized bank means a bank which is defined under Banking Companies Acquisition and Transfer of Undertakings Act 1970. Let us move to explanation 2. Transaction is considered to be a commercial transaction if it is taken for the purpose or if it is connected with any industry, trade or business. Let us move to subsection 2 under section 34. If you recollect the third point what we saw, it says from the date of decree to the date of payment, court can direct payment of interest. But in this case what happens is the court is silent about it. The court is not saying that interest should be paid from the date of decree to the repayment of the money. In that case, it is deemed that the court is refused such interest, and for this purpose a separate suit cannot be filed. You cannot file a suit to the court saying that you ask him to pay me interest from the date of decree till the payment of the money. It will not lie. If you like the video, please do press the thumbs up button and leave your comments in the comment section. And do subscribe the channel and also share the channel with your friends. Let us join hands together and contribute for a learned society. Thank you.